My lords, one loose end, quiz close trusts.
Yeah, well, we know all about that because my initial assistant who's in court has managed to drum up a extremely helpful and erudite note on his decision, Mr. Justice Snowden, as he then was, in Carluccio's restaurants, followed by Justice Trower and Debenhams, and the answer is no, quiz close work for various reasons. Although, interesting enough, that decision of Mr. Justice Snowden was actually before it came into effect. It was actually the 13th of April 2020, which is very early.
Yes, they were going on the initial guidance, but they didn't have the direction.
Yeah. So don't worry about that.
That's okay, thank you, that's useful.
Thank you. Thank you very much.
It was Miss Higgs came up with it as well.
Thank you very much.
There goes that treat. My lord, Furlough Authorities Bundle 1.
Yeah.
Not going to do every case, but one of the origins for these principles is the Castellane case, which is at tab 6. And it's more for the comments made by Lord Justice Bowen that are later been cited. The case was a property insurance. The owner had a contract to sell the property. The property was damaged by fire, but the owner was paid the purchase monies without any reduction on account of the fire. And if we go to page 44 at the top, it said, and of course this is not a cease or reduce clause, it's a question of the loss. And you see about 6 lines down it said, did the right diminish the loss? And if you see, and the second paragraph, which says with regard to gifts, and the question there is, well, when you look at the benefit, has the loss been in substance reduced by anything that has happened? So it obviously has echoes of the cease and reduce clause, but we're not looking at it for the wording of the cease or reduce savings clause. In the common law legal causation test as to what the loss is, you do take into account a benefit that has in substance reduced the loss, but the character comes into play. So there's then a discussion of Bernard and Rodacanacci, where that case there was an actual intention expressed as to whether the sums would reduce loss or not. But then at the foot of the page you have, suppose that a man, and we also suppose that his brother offers to give him a sum of money, and it said over the page that the effects will depend on the real character of the transaction. Did the brother mean to give the money for the benefit of insurers as well as for the benefit of the assured? Now, there's no suggestion that the brother needs to have said one way or the other. It would be an odd brother that thought of that. There probably are such insurance brothers, but the idea is that one looks at the character. We'll see this from the later cases. The character, and here the benevolence means that it's something that's not to be taken into account as reducing the loss. Now, perhaps closer, both in time and to the sorts of questions we're considering, if we move forward to tab 19, we have the merit case. So you can see from the head note, it's a reinsurance claim and a liability policy, and that the brokers had paid $45,000 to the reinsured without any legal liability to do so, and that's summarised in the first paragraph of Mr. Justice Staines' judgment on that same page. And then if we go forward, it's a short judgment on page 227, left-hand side. You can see in the second and third paragraphs that the arbitrators found that the sum did fall to be deducted. And then in the fourth paragraph, the starting point is that that sum was recoverable by the reassured from the reinsurer, i.e. it fell within the indemnity. And the question is whether the subsequent funding or payment of the sum by the brokers precludes that recovery, even though they had no legal obligation to do so. So the insured or their reinsured has received a sum that funds or offsets 45,000 of its loss which otherwise falls within the indemnity, and the question is whether the receipt of that money diminishes the loss. And the arbitrators thought that it did. And you see further the paragraph quoted at the top of the right hand side. Which concludes that they were out and out payments without conditions. And that the reinsured couldn't claim against reinsurers in relation to those funds. Now, it's not exactly the same as our case, for the reasons I've given, but you see at the bottom right paragraph of that page, under the realities of the situation, firstly, in this case, which is not the same as our case, the reinsured has undertaken to pay that money back to the brokers if it recovers it from the reinsurers. And we can come back to that. There's no, decides not to go on and consider whether there's a constructive trust against the reinsureds. And doesn't think that the reinsurers, sorry, I'm going too quickly. Let me look at the actual words. You see at the foot of that page, bottom right on 227, on the other hand, if capital reinsurers succeed, they will receive an uncovenanted windfall in the sense that Merit will have paid a sum which they were liable to pay. And it seems to me tolerably clear as the law stands, brokers have no claim against capital, the reinsurers. So the brokers would have paid a sum which the reinsurers were obliged to pay, i.e. some of their indemnity liability covered by somebody else, and that's a windfall, and that's the sort of windfall that we rely on here too. Paragraph 228, left-hand side, the paragraph beginning "this does not." The last sentence says that the law is fairly clear, and then the point is a short one, that it was a gift, albeit for commercial rather than purely disinterested purposes. So the benevolence concept, as applied in these cases, isn't strictly limited to brothers and charity. It's more that it's something given without obligation or consideration returning in the other direction. And it was for some of the purposes that benefited the payer. They had a reason for doing it, which was goodwill, just as the government in our case obviously wanted to incentivize the retention of employees for the benefit of the economy and protection of the employees. But it was nevertheless gratuitous. In our case as there. Now, as to the undertaking to pay back, which doesn't come up in any of the other cases, we don't think that that's relevant. All the cases talk about the intention of the donor to benefit the donee, not the intention of the donee to repay. And this is not ultimately a matter of policy, it's a matter of the test of legal principle of causation applied to the facts. This is a test case. If the court did say, well, it makes a difference, well, people would know that, and they may decide, well, rather than the insurers get the benefit, I'd rather the government did. But that's not our case. This case has been brought to to keep the sums that were received rather than for the insurers to get the benefit of them. If we turn to Atlas Navios, the B Atlantic, that's at Authorities Bundle 2, which we're still in, but tab 25. There are many decisions on this case, but this one was also of a Mr. Justice Flow. Tab 25.
Sorry, tab?
25.
Oh, it must be in the other bundle, I think.
Bundle 2.
Bundle 1.
Sorry, Bundle 1. I
Yeah.
keep saying Bundle 2. So I've written that down. My lord, the B Atlantic vessel was seized by the Venezuelan authorities. There was a war risks policy.
Yeah.
And the right-hand side of that first page shows a sue and labour clause by which the insurers are liable for legal and other costs. That's under the policy contained on the right-hand side. And then at 345.4, you can see we're into the quantum of the sue and labour expenses. So that's the bottom right of 345. But we're interested in subpoint B, which is on page 346. And then C on page 346. So C, there's a 1.4 million cost incurred by way of legal fees, recoverable in full, that's under B. And there's a question about whether the expenses were solely for this purpose, and that's said not to matter, as is well known in expenses cover. And then at C, we have the fact that some 1.2 million by legal fees was funded by the owner's P&I Club Guard on an ex gratia basis, was raised inter alios actus between the owners and the insurers. Voluntary funding was to be disregarded. And we see that if we go to, we perhaps need to see the involvement of Guard a little bit. That's the P&I Club. Just by way of example, if we look at 356, on the left-hand side, you'll see that the P&I Club were involved in the early stages after the seizure. And then at 360, paragraph 70, there's further involvement of P&I correspondent. And at 112, which is on page 367, you'll see that the owners relied on the fact that they were members of Guard and were well reputed, and the Venezuelans shouldn't think that they were involved in the wrongdoing which was the cause of the seizure. And then at 375, paragraph 150, you'll see that there was no club cover, and therefore Guard wouldn't put up the security. And then if we go forward to the reasoning at 412 of my lord, which we would describe as brief but correct, at 347 to 8, my lord deals with this point. Which is that the insurers would get a windfall. The brokers didn't expect a reimbursement. And it said that just because Guards funded the fees, where the funding is voluntary, this is in 348, therefore does not diminish the reinsurer's losses to be disregarded. So not like merit in that there's no reimbursement to guard, it's just a voluntary payment that will be kept by the insured. But the same windfall argument that here the insured is going to get its full indemnity plus keep that sum, and the law rightly has no problem with that because the payment is treated as res inter alios acta because it's voluntary. And we'll see what my learned friend says about those cases because he doesn't deal with merit or the Atlantic in his skeleton, I don't think. Now, one thing that he not wrongly does touch on, because we do too, is the most common situation in which there are public payments considered in the res inter alios acta context, and that's social security. And generally, the position that has evolved is that, well, they're state payments, but they're not like the grants we're concerned with, we say. They are paid in volume as a pre-existing safety net, a social security net. We'll look at it in a minute. So you've got income support, sickness benefit, universal credit, statutory sick pay, etc.
Yeah.
Indeed, even the fact that the NHS provides healthcare for free, which otherwise would have to be paid for, that's a gratuitous benefit provided by the state. Nevertheless, they are taken into account and not deducted when calculating the damages payable by a tortfeasor who's caused personal injury and variously by an employer for wrongful dismissal. You don't assume that your employee who hasn't yet secured another job received nothing. You do take into account their unemployment benefit. Now, we say, firstly, that's a highly political question. Since 1948, there's been legislation for some of these benefits. And since 1989, there's legislation that all of them are deducted from damages, but the tortfeasor must then repay the government. Now, I don't think I need to go there, but because I doubt it'll be controversial. Part of that summary is covered in McGregor in the bundles in Authorities Bundle 3, tab 45. At 1145, there's more that's not, which we can provide if need be, that sets out the legislation and how that works. But I think it will be agreed that the scheme since 1989 is that these are deducted from the damages by legislative provision saying so, but that the tortfeasor then has to repay the government. I will show you Hodgson and Trapp, which is relied on by the defendants at Authorities Bundle 1, tab 18. This is the House of Lords case in the middle of all of that. It's just before the 1989 legislation, but it's after some of the earlier legislation. So this is a personal injury case where there's an attendance allowance and a mobility allowance. And if you go to page 210, my lords, and you look at D onwards, you can see the modern position on social security is evolving. D onwards cites some of the earlier cases, then quotes Parry and Cleaver at the bottom, and including the last sentence of the Parry and Cleaver quotation, where it was said by Lord Reid, may be thought that Parliament did not intend them, that is the welfare state payments, to be for the benefit of the wrongdoer, and the law has moved away from that position in relation to welfare state payments. And if we go on to page 212, you'll see at B to C, Lord Bridge saying that looking at the intent of the person conferring the benefit doesn't make much sense in the context of statutory benefits. They come from the taxpayer, prompted by humanitarian considerations directed at meeting certain minimum needs of the disadvantaged. And it then says Parliament can provide expressly, and in fact it does so in the 1948 Act, and then later, as I say, more so in the 1989 Act very shortly after this case. In the absence of the provision, I can discern no general principle to support Lord Reid's opinion that Parliament did not intend them to be for the benefit of the wrongdoer. that doesn't mean that Lord Bridge is saying that there's a general intention that they are for the benefit of the wrongdoer. He's just saying he doesn't think it leans one way or the other. And then at the top of 213, he says, in the end, it's one of public policy. Now, legal causation is one of the most vexed questions of law, in fact, and it's often said that public policy comes into it, especially where you've got something like a public body, or indeed charity, because there's the law desires to encourage charity and not discourage it by meaning that charitable donations will ultimately not benefit the donee. But here we have a summary in that paragraph of how talking about benefit to one or the other or benevolent donor is entirely artificial, and the position concluded in relation to these benefits is therefore that they should be deducted, and the same is true for various other benefits. As I've said, it's now legislated. So we say that, well, the way the law treats welfare benefits from the state, which are pre-existing safety net, so if you injure someone negligently, you're entitled to have your damages limited by the fact they're able to get NHS assistance and such basic benefits as they're entitled to, because those pre-exist and they sit as the social structure around which people live and indeed interact, and therefore wrong each other in the tort context. But that's not to say that public benefits will always be deducted. So a couple of examples. If we go to tab 15, which is a case outside the policy-heavy personal injury context, you'll see it's the case of Tremel. It's a provisions case of valuers, and there was a particular grant, a local authority grant, to assist with the remedial works. So it's linked to the specific works. It may even have netted off in accounting, who knows about that. It was discretionary and it was disregarded in the claim. If you just go forward to 157, you'll see at 1309, final paragraph, there's a grant. The grant's paid under the Housing Act as a discretionary grant, and then my lords might skim the next page, but if you look at the top of 159, the first basis is not relevant to us, and the basis there is it said, well, the measure of damages is difference in value, not cost of cure, so the grant towards the cure doesn't matter. But then the second ground, so obiter, it said, well, it's a collateral benefit. And there's no intention expressed either way by the local authority. We also go to tab 24, not tab 24, sorry, tab 16, the next tab. You can see from the head note, this is a case of a regional development grant that funded a move to new premises, and it's in the context of a compulsory purchase valuation, but it's agreed that the principles of valuing a compulsory purchase amount reflect the common law. That's at 170E. And then if we look at the actual reasoning in the case at 170G, so we've got a grant that's related to specific expenses, and the question is, well, is the loss diminished thereby? And we see the windfall argument at the bottom of that page, and then at 172, H and onwards, we see that the grant was to induce, it was a grant that induces people to move to a particular area rather than another area. So after the compulsory purchase, the claimant had to move to somewhere, and they were induced to move to a particular place by this grant that would cover their costs, which were costs that followed the compulsory purchase and so were otherwise recoverable. And it was said it's not deductible and said to be correct. And we can see further reasoning of the Master of the Rolls at foot of 174 and the top of 175. It's not in compensation for the dispossession, it's payable whether or not there's a change of ownership or location, so long as it relates to expenditure of a relevant kind. They're incentives for industry. That's at the top of 175. And of course, each grant has its own purpose. You have to construe the statute, such as you have material. But we say that there are parallels here. The CJRS was not a compensation for losing revenue. It was a reward for choosing to incur the expense of the wages. And it's from a public body, and it's in response to the need to move in that case. In our case, it's in response to a peril faced rather than being a pre-existing welfare state payment. And we say it's collateral. We rely on the Design 5 case at tab 17, but I won't go to that now. I will go to one of the earlier welfare payment cases just because it raises a particular point. It's Foxley and Otten that's at tab 11. There's not much to take from this case, my lord, other than you can see at 83-4 that a particular benefit here, which is discretionary national assistance grant, which is a successor of the Poor Law, does not fall within the general welfare benefits process by which they are to be deducted. It doesn't have the same conclusion because it's a discretionary response to a need of a particular person. Now, of course, in our case, and welfare payments, I say, are different anyway because they have the particular policy issues of social security and personal injury. And nevertheless, our case, the CJRS was not discretionary because it was made available as of right, but it was nevertheless made available in response to the problem that was the COVID pandemic. And we disagree with Insurers Skeleton 58, where they say there's a blanket rule for all state payments. Because we say that these grants, like in the cases we've looked at, are collateral to the insurer relationship and to the cover for revenue that's being provided. And they're benevolent. And they're not a basic social welfare. They're a ad hoc, albeit ad hoc across the whole country, but it was enacted in response to a particular pandemic rather than a generalized unemployment or other benefit. And just to take a couple of other points from our skeleton, if we look at paragraph 84, without going to these cases, my lords, that's the core bundle. Tab 1, not tab A. You see at paragraph 84, which is at page 26 in the bundle paging. you'll see that some of the cases fall into the category of considering funding and give rise to the general view of the law in the context of causation that doesn't really matter who pays for something as between you and the person you're paying. And these cases that we cite there, as Lyndon Gardens quoted, in Hamilton Jones, which is in the footnote, Miss Justice Neuberger says it would be absurd to consider how the claimant funded something. It's none of the business of the defendant. There's Lowick Rose, which I've already taken you to. Paragraph 85 touches on the wrongdoer issue. If a wrongdoer destroys your property but then pays you some money, that obviously is to be taken into account. And we disagree with the insurers in their skeleton at 69, where they say, well, the government's like a wrongdoer here because the government caused the problems by imposing the restrictions. The government was not, by the CJRS, firstly the author of the pandemic, obviously, but also was not seeking to compensate for lost revenue that it had caused. Rather, it was seeking to intervene to reward the continued employment of employees and to incentivize that. And it did so by funding it. So we say it's not one of those cases. It's the case of a third party to the insurance stepping in for these economic reasons. My Lord, just briefly now, the cases on the actual COVID benefits, so that's Stonegate in our case. If we go back to Stonegate, but on this point, that's at Authorities Bundle 4. It's at tab 4, and if you go to page 368, so what happened here was paragraph 271. Judge explains why it's not strictly necessary to consider the general law, because in that case you'll recall that the concession was made that the CJRS and the business rates relief were in consequence of the peril there being disease anywhere in the country. And accordingly, he says it's not strictly necessary for me to go into the general law, and he says I doubt that if they're in the savings they would be covered by the general law. So he's here considering what if the savings clause doesn't apply. So he's not considering the inconsequence of wording. He's saying what if the savings clause doesn't apply, but there were a general right to subrogation to the benefit even outside that clause, which he doubts. And as I say, the insurers don't press in this appeal, nor did they below. But he nevertheless considers some of these cases, but on that particular basis. And at some of the case law, therefore, some of which I've gone to, and if we go forward to 284, we'll see the propositions that he takes. He concludes that the benefits to be taken into account unless the intention to benefit the insured to exclusion of the insurers can be derived. We take issue with that. The rest of it is generally inoffensive, but we take issue with the suggestion that it's only if you can get a clear intention one way, otherwise you presume that it's to be deducted. I think I've shown you, including from Merit and Atlantic B, there's no reference to such a leaning or a burden. 286, therefore, seems to put the burden wrongly on the insured. We say the legal burden's on the insurer, but in any case, the question is an open one. And you just look at whether it was gratuitous, etc. He says at 286, he relies on the fact the government didn't indicate either way here, which is of course right. even though it was aware that some companies had BI insurance. Well, it was. We say you can't draw any conclusions from that. In many cases, such as the P&I Club or the broker payments, the donor's obviously well aware of the insurer but still says nothing, and that's no bar to the sum being disregarded. The CJRS regulations were made in April, 14th of April, and after the announcement of lockdown and measures only less than a month before, this was high speed, and there's no reason to think the government then thought that there would be a substantial body of business interruption that would respond to these claimants, and indeed it took a test case to establish that there was any. So we'd say that point doesn't have any force. You can't read from the silence that the government intended that the insurers should take the benefit, and that standing back the general character of the payments as gratuitous and intended to benefit the insured and their employees points against deducting the sum. And if you ask the question, who would you think is intended to benefit out of the insurers and the insured, we would say, well, it's the people being paid, it's the insured. My Lord, Mr. Justice Jacobs is at core bundle tab 1. Sorry, tab A, yes. And if we go in tab A to A97, we'll see at paragraphs 454 to 5, my Lord reached the conclusion that having found against us on the ground 2 point, which is Mr. Gruder's going to come on to address, there wasn't any need to deal in detail with any further arguments about collaterality. And he says in 455, suffice to say he was unpersuaded that they could be equated with benevolent gifts, which we say is the wrong test. If you're, obviously that they have to be equated with such payments as are collateral, but there's no category definition of benevolent gifts, and we've seen that that label doesn't fit with merit and it doesn't fit with B Atlantic. Those are just payments that are gratuitous, which I think is a more accurate description for the test, my Lord. So we say, well, Mr. Justice Jacobs didn't give any detailed reasoning there and followed Mr. Justice Butcher, and that Mr. Justice Butcher wasn't actually considering ground 3 as an argument. He was considering it obiter in case it arose if the insurers argued that they had a general right of subrogation. And we say the point is, in any event, obviously open to this court. To conclude on that, my lords, we say the CJRS payments are collateral. They're gratuitous payments from a third party to the insurance, like in merit, like in B Atlantic. They're not compensation for lost revenue, which is the claim. They're not part of a pre-existing social security system. They're responsive grants made to encourage and reward the employers continuing to employ and to support the businesses. And that purpose is best met by the insureds retaining them, not by them being credited to the insurers, which serves the purpose not at all and is at best neutral to that purpose. So, my lords, we say that standing back as one has to with these common sense appraisals such as legal causation, these payments from a third party, which are there accidental as far as the insurer is concerned, they were not brought about by the insurer. They came about as luck due to the choice of the states to try to bring about certain results, and they shouldn't be treated as in consequence of the saving of the wages. My lord, those are my submissions subject to reply. Mr. Good is now going to address ground 2 unless there's anything you...
Thank you very much, Mr.
Thank you.
Green.
Just take that.
Of course.
Just here. Lord, sorry. Thank you. I am dealing with it in consequence of, but I do want to pick up 2 points which were made this morning. The points I wish to make are, first of all, the scheme is the scheme. It's not good enough to say it could have been done in some other way, or in substance it achieves the same object as some other scheme might have achieved. And the second point I want to make is this contract which we are dealing with, the savings clause, is effectively a standard clause in policies. Maybe the wording differs slightly. It's something which has been drafted very carefully. Everyone agrees that the parties agreed that formula, and you apply that formula. You construe that as you would any other very carefully drafted contract, commercial contract, between
Why do
sophisticated...
we assume it's drafted very carefully?
Pardon?
Why do we assume that it's
Well-
drafted very carefully? Because quite a lot of the contract isn't drafted all that carefully.
Well, it's between professional parties.
I
It's
understand that point.
and if I can make this point first of all, to show you an authority which unfortunately is not in the bylaws, but it doesn't say anything new. It's a case called Bellini and Britt. It's an authority which I can give my lords. It's an authority of the Court of Appeal which was decided last year. It applies the general rules of construction to achieve a result which some might consider surprising. It wouldn't be right for me to criticise a decision of the Court of Appeal in any way whatsoever, especially since I was the losing counsel in that case. But it is a case where a contract, a business interruption contract, provided cover for inter alia business interruption caused by the presence of an infectious disease within 25 miles of the premises. But there was wording in the contract which effectively suggested or effectively said that there would only be cover if damage was caused to the premises or the contents. And on one view, that was perhaps a rather absurd conclusion, that how could an infectious disease 25 miles from the premises cause damage? And one argument put before the Court of Appeal was there must have been a mistake in the drafting. It was so absurd. And the Master of the Rolls gave the judgment of the court, and he, for example, at paragraph 21, referred to the well-known passages in Arnold and Britton, and on page 1619, he referred to paragraph 17 in Arnold and Britton. So the reliance placed in some cases on commercial common sense and surrounding circumstances should not be invoked to undervalue the importance of the language of the provision which is to be construed. The exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader, and save perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. Unlike the commercial common sense and surrounding circumstances, the parties have control over the language they use in a contract. In paragraph 22, he then cites from his own judgment in Brickvick, he says, I summarise the effect of wood and capita. In Wood and Capital, Lord Hodge rejected the suggestion there'd been any change in the approach to contractual interpretation. There was no need to reformulate the guidance in Rainy Sky and Arnold and Britain. The latter had not recalibrated the former. The recent history was one of continuity rather than change. And then if I can jump to the last 5 lines, Lord Hodge drew a distinction between agreements that could be successfully interpreted principally by textual analysis, for example, because of their sophistication and complexity, and because they have been negotiated and prepared with the assistance of skilled professionals on the one hand, and where correct interpretation may be achieved by a greater emphasis on the factual matrix, for example, because of their informality, brevity, or the absence of skilled professional assistance. The representative member relied on Lord Hodge's statement that there may often be provisions in a detailed professional drawn contract which lack clarity, and the judge interpreting that provision may be particularly helped by considering the factual matrix and purpose of similar provision in contracts same type. And the Master of the Rolls, at paragraph 28, says, in my judgment, the court should apply the authorities I've tried to summarise, paragraph 7024 above, as the insured's argument acknowledged it was only permissible to rewrite clause 826 if something indeed had gone wrong with the language used. If not, then the clause would have to be given its natural meaning. If, as was effectively acknowledged, also it was not ambiguous on its face, even it did provide only limited additional cover to the cover provided in clause 8.1. And then he says, I do not think anything has gone wrong with the language of clause 826. So the insured did not have any cover for infectious diseases such as COVID within 25 miles of the premises because he could not prove a fact which it would have been impossible to prove, that COVID within 25 miles of the premises caused damage to the premises or the contents. So when one looks at the saving clause in the Starboard or the Gatwick, you apply that word through the word. You don't say, well, in substance they might have said something else, or in substance you can achieve the same object by doing something. This is a formula the parties agreed, and you apply that formula properly. The second point is the scheme itself. And there is another authority, which is the Debenhams authority, which followed on from the Carluccio authority. And if I can hand you that judgment.
This is Mr. Justice Trower, is it?
Well, no, it's the Court of Appeal. It's the Court of Appeal. It's Court of Appeal, which was the Chancellor, who was then Chancellor Voss, Lord Justice Bean, and the judgment was given by Lord Justice David Richards. And if we can go to paragraph 20, paragraph 20 sets out features of the scheme which were important for the appeal. And those features are set out. It might be that I can ask you to read paragraphs 20 to 27 to yourselves.
Okay, let's do that.
Then I'm going to go to paragraph 55. And the issue in this case is whether the administrators had adopted the contracts of the employees in the context of the furlough scheme. Paragraph 50, the issue is therefore whether the administrators have continued the employment of the furloughed employees. That is an issue to decide reference to the evidence for the court in particular case. Following facts tend to support the conclusion administrators have continued employment of the furloughed employees. First, administrators will continue to pay the wages or salaries of the furloughed employees up to limits provided by the scheme. Those will be payments for remuneration pursuant to their contracts of employment, subject only to the limit. The employee's entitlement to their payments is derived exclusively from the contracts. This is reflecting the tax position of both the employees and the company. The remuneration will be income in the hands of the employees, chargeable to income tax, which will in all or most cases be collected through the PAYE system. The remuneration will be expense of the company's trade, and payments by the government under the scheme will be income of the company for the corporation tax purposes. If I can pause there, this isn't some fiction. This isn't in reality the government paying the employees, as was suggested as a possibility this morning. This is a matter not only of the letter of the law, but the substance of the law, from which real world consequences flow in terms of liability to income tax and corporation tax. 58, second, all the furloughed employees who've accepted the continuation of their employment on these terms, and those other employees who do not treat their contract as terminated by reason of the company's failure to pay their full contractual remuneration, will remain bound by their contracts of employment, save only as regards the obligation to be available for work during the furlough period. For example, as the scheme states, furloughed employees are free to undertake voluntary or paid work for others, but only if permissible under their employment contracts. They remain bound by duties of loyalty and the like. They will remain available, and they will be obliged to provide their services to the company as and when it's able to reopen its stores. And then in paragraph 60, Mr. Smith relied on three principal points for the opposite conclusion. And I'd like to go to paragraph 63 at this point, to his third point. Sorry, the second point. The second factor on which Mr. Smith relied was that while the employees are furloughed, their remuneration is limited to the amounts payable under the scheme. The effect is therefore neutral as far as the administration is concerned. In economic terms, the company, this is his submission, company is a conduit for the payment of government funds to the employees. We do not consider that this is a well-founded point. The legal analysis is clear as explained above. The furloughed employees remained employed, and they are paid the remuneration due under their contracts, subject to the maximum under the scheme. The remuneration is an expense of the company, and the government grants are income of the company. The government could have devised a furlough scheme which did not involve using the employer as a conduit for the remuneration, but it did not do so. The legal consequences of the scheme must be decided by reference to its actual terms. And I would rely upon that in the context of certain of the remarks which were put to Mr. Kramer this morning.
That's all addressing the question of whether the administrators are the people who are employing the furloughed employees.
Yes. But that is economic terms. I'm going to take, although invoked by Mr. Smith at paragraph 63, I'm going to take that question very much further, are they? Well, the scheme is the scheme. The fact that it could have been...
I understand you rely on that, but it's in the context of the scheme is the scheme by reference to whether the employees are employed by the administrators.
Yes, well that was the, whether they adopted the, yes, I quite accept that. wasn't in this context, it was an insurance context, I accept that. So now I can turn to the point which is my point, which is in a sense the second point, in consequence of the incident, which in this context means insured peril, and that there are just one or two features of the scheme which I would point out, which I'm sure my lords are aware. The scheme operated from April 2020 until September 2021. And the scheme operated in that period, in periods when there was no forced closure of businesses, because the type of businesses which involve my clients, which are hotels and restaurants and cafes in there, were able to open on July the 4th. There was then a second lockdown on November the 5th. They were able to reopen again, I think it was the 2nd of December. Then there was a further lockdown at the beginning of January. I'm ignoring local lockdowns for the moment and rule of 6 and early closing, but the point I'm making, and then of course hospitality could fully reopen in May 2021, but the scheme continued. So the point I'm making is a general point. The scheme did not only operate at a time when there was forced closure. And the point in terms of the wording is that it's not any sum saved which is credited to the insurers in the calculation of claim. It must be saved in consequence of the incident, which means in consequence of the insured peril. And you've already seen paragraph 162 of the Supreme Court judgment in the test case, that in consequence of is a wording of proximate causation when one does see that in an insured policy. So when it says in consequence of the incident in the savings clause, or as we, I think, all agree in this context means in consequence of the insured peril, we would submit that it means that the insured peril must be a proximate cause of the saving. And of course, it would be a proximate cause of the saving if the insured peril were a fire, for example. The fire burnt down the hotel, therefore the hotel obviously lost revenue, but there were savings because the hotel didn't have to order food in, didn't incur electricity or gas costs and so on. The fire would be a proximate cause of the saving in that case. Therefore, now the furlough scheme, a furloughed employee is defined in the furlough scheme as an employee who's been instructed by the employer to cease all work in relation to their employment by reason of circumstances arising as a result of coronavirus or coronavirus disease. Now, that is a provision of the April 2020 scheme. But of course, of course, in terms of the insured peril in this policy, coronavirus or disease was only part of the insured peril. Effectively, it was only the danger part of the insured peril. There was nothing in the scheme which required the employer or the business which was making use of the, if I can call it the furlough scheme, because it's much easier than CJRS, making use of the furlough scheme to show that they had been compulsorily closed. They didn't have to show that.
Did you have to show that in your insured peril?
Well,
Can we just
there
look
was a
at,
prevention of access.
can we just look at your insured peril? Because I'm not sure your insured peril is the same as the Bath Racecourse one.
Well,
Right.
if one looks at
Page
for example, page 140 of Starboard,
And am I right in understanding that the insured peril element of this is the composite elements
Is
of
the
the causative?
action-
There are three causally interrelated.
action
Insured perils,
by
isn't
the police, well, action
Well,
by
stage one, in terms of origin, is danger or disturbance within 1 mile of the premises.
Correct.
That was then be followed by, using the following word, action by the police or
Police
other
or
statutory
statutory
authorities.
authorities,
So in other words, government lockdown in this case.
which
And then
prevents.
thirdly,
Yes.
which prevents or hinders use of the premises or access thereto, or interference with the business. So in your case, although not in the Bath Racecourse case, the third element doesn't require, does it, that the lockdown, the action by the statutory authority, prevents or hinders use of the premises or access. It's sufficient if it interferes with the business carried out.
That's true, but well, Miss Higgs points out it actually doesn't, in a sense, make sense because hinder use of the premises or access thereto, or interference with the business carried out by the insured. It sort of doesn't.
Well, that's because they've used a noun rather than a verb. What
No,
they
but
mean is shall interfere with the business.
But at the end of the day,
Well, it's perfectly good grammatically, isn't it? Which shall, pause, either one, prevent or hinder use of the premises or access thereto, or two,
interference with
interference with the business carried out by the insured.
Yeah.
But that's obviously what it means, interfere with the.
But there are, for example, so what you have to show is a danger within 1 mile of the premises. You have to show to have a claim under this provision, at least one case of COVID after the 5th of March 2020, but let's not worry about that. At least one case of COVID within 1 mile of the premises, and you've got to show action by the statutory authority, which shall prevent or hinder.
Your clients who are running hotels, Gatwick and Starboard both, their business was interfered with even when the initial lockdown stopped, because there were all those social distancing requirements and people having to sit at tables so far away from each other. And then in due course there was the rule of 6, and goodness only knows
That's
what
right,
else.
rule and early
But that was all
closing.
interference with the business, and presumably a substantial proportion of your overall claim relates to that period.
Well, there is
I say
a
your claim, I mean
there
your
there
claim
is a
of business
dispute
interruption.
relating to that.
Yeah.
That is true, but of course the problem with this is that we don't have a claim for that because the policy's expired at the end of June 2020.
That was
So we don't have social distancing. We don't have rule of 6.
well.
We don't have
The Gatwick policy didn't expire until the 7th of October, so they were clearly affected. I mean,
They
they're
were
still
affected.
they're still appellants in this case, aren't they?
They are.
Yeah. So
They
the point I've just made holds good for them.
And indeed,
I think rule of 6 was introduced from recollection in
September
18th of
2020.
September, wasn't it?
I mean, the point's in a sense a wider one, in that unless, and save to the extent that there is an interference with the business, there won't be a claim.
No, but
Nothing to save in
so-
relation to.
yeah, but at the end of the day, it is a requirement that you have to show action by effectively here the statutory authority. That's a sine qua non, and following a danger within 1 mile of the premises. Neither of those requirements were sine qua non of a claim on the furlough scheme. So, for example,
Is that right? Let's take them in turn. Let's take the individual case of one person with COVID within 1 mile of the premises. We know from the Supreme Court decision that individual case was a proximate cause of lockdown. Yes. So we then say, well, was lockdown a proximate cause of the furlough scheme being introduced? To which I would have thought the answer is obviously yes. The two are inextricably bound up together. They're announced at the same time. So just if we take that element of the insured peril, why is not the individual case of COVID within 1 mile of your premises a proximate cause of the furlough payments that you receive? Now, that's only one element of the insured peril, but take that element of it. Why isn't the proximate causation in relation to the furlough payments in that respect?
That's what the judge said effectively in I think paragraph 455 or 445. But
why is
the
that
answer,
wrong?
well, he's wrong because at the end of the day, that's only one. If that argument were right, that's only one element.
Well, I'm going to
Of
take
the
it. I'm going to
peril.
take each
Take the
element.
others.
I just want to take them one by one. That's the first element. Right? The second element is that there must be the action by a secretary which follows that
Well,
incident of
except
COVID.
you can claim furlough, and people were perfectly entitled to claim furlough, irrespective of whether there was disease within 1 mile of the premises, irrespective of whether they were closed down. If you were a corner shop, a corner grocery shop, you were perfectly entitled to claim furlough because your business could have been affected by. Your customers would have been scared to come out. Some of your customers might have died.
Mr. Good,
People
we're
were-
not concerned with the corner shop who didn't have a claim under its insurance. What we're concerned with is your two sets of clients who ran hotels, who've made massive claims for losses they suffered under their insurance, precisely because they suffered losses, business interruption losses, that were proximately caused by this peril. And by which I mean all three elements of the peril, because otherwise they wouldn't have a claim.
No, but we were not. We did not have to prove any element of the peril in order to claim furlough at all.
Well, but furlough arose from, or was proximately caused by, each of these perils. We've paused after the first of one, but I would like to go through them all. The incidence of a COVID case within 1 mile of your premises, or the individual premises, was a cause of the lockdown and therefore the furlough scheme. I think so far you were minded to say yes, or you didn't really have an answer to that.
No, the furlough scheme was brought into effect because I think it's fair to say, obviously the government were going to lock down businesses or did lock down businesses. But I would have to prove, in fact, that, and indeed it's now accepted, that a case, if there was a case of COVID within 1 mile of my premises, that was the cause of the government regulations.
Yes.
It's rather different in my respectful submission to say a case of furlough within 1 mile of the premises, my client's premises, was a cause of a furlough scheme.
Why? If the furlough scheme was part and parcel of the lockdown, why doesn't the proximate cause analysis of the Supreme Court apply equally to the furlough scheme?
Well, because there is a decision of the Supreme Court which says that the regulations were caused, the regulations which closed businesses such as my client's business were caused by each and every case of COVID which had come in, well, either known or unknown, which had occurred, but by the time the regulations were brought into effect.
And the furlough scheme was effectively the quid pro quo for the government having had to close down all the premises by virtue of the regulation. And you may be right that there were individual premises where employers claimed furlough who didn't have a claim under their insurance because
Well,
they
you
had
didn't, with all due respect, all you need, you did not have to prove that there was a case of COVID within 1 mile of your premise. You did not have to prove that you were locked down in order to claim furlough, because, as I said, if you were business, which was perfectly, if you were, say, a grocery shop, and you didn't have an online business, and therefore customers had to come into your shop personally, you might have suffered an enormous downturn in business, because at that time people were frightened to leave their homes or transfer their orders for food online, and therefore you might have wanted to lay off your employees or some of your employees because your business declined. You would have been perfectly within the rules in those circumstances if you were that business to claim furlough, and yet you would not have to prove that there was a disease within 1 mile of your premises. You would not have to prove that you'd actually been closed down by the government in any way whatsoever.
What we're concerned with is the savings clause in the policy of insurance,
Yes.
under which claims have been made by these insurers. We're not concerned with other people who may or may not have had an insurance claim. And the reality was that to some extent, I mean, I'm now recollecting rather dimly what we decided in the divisional court case, but I mean, there were various policy wordings, some of which were 1 mile wording, some of them were 25 mile from recollection, some of them were vicinity wordings, which basically covered everybody. But I mean, 1 mile and vicinity wordings, I seem to remember there was some suggestion at some stage that COVID hadn't affected limited areas of the United Kingdom. I have in mind, I think the Scilly Isles was one of them, or possibly the Orkneys and the Shetlands. But basically it covered the whole of the UK, because whichever test you took, there was going to be COVID within the relevant radius. And that's why there was such an enormous series of claims. Now, true it is, there may have been people who didn't have an insurance claim for some reason. They're not trying to fight being brought within a savings clause,
Well,
which is what you are.
Well,
Anyway, sorry, we're taking you out of your
I'm not
savings.
seeking to bring myself in the same. It's
No, you're
the
seeking to-
insurer who's seeking to bring themselves
Yeah,
in the savings
Yeah, you're seeking
clause,
to fight
and
being
they-
brought within it.
and they have to prove effectively that our receipt of furlough was in consequence of the insured peril. And my case is that the insured peril here was effectively the insured peril which one sees at either one sees it at 140 of the Starboard case, and we say the insured peril is not the proximate cause of the receipt of furlough, because the insured peril itself, we say, was actually irrelevant to our claim for furlough. All we needed to do was to show our business, in a sense generally, was affected by COVID-19. We didn't have to prove the requirements of the insured peril, that there was a case within 1 mile, or that we were actually our business was access to our business was prevented or hindered by government regulations.
Well, I think if I understood your argument, it is that although the danger or disturbance within 1 mile could be said to be the proximate cause of the lockdown, and the lockdown could be said to be the proximate cause of the furlough regulations, that was not, the furlough payments under the furlough regulations were not proximately caused by the individual case within the radius, because furlough payments would have been payable but for the existence of that one person in the area. Is that a fair way of putting it?
Well, that's one way of putting it, certainly, my lord.
Well,
It is a fair way of putting it, my lord, yes.
And so what you're essentially saying is, in the context of this, and this is perhaps as if not more important for the Bath case, which does require prevention of access, you say you apply a but-for test of causation to each of the three constituent elements, causally linked elements of the insured peril. You say that's how the proximate cause test has to be applied in relation to savings. Is that, have I understood you right?
Yes, I mean, effectively, you've got to show, or the insurers have got to show, that the payment of furlough was in consequence of acts being prevented or hindered by the government, statutory authority, by reason of a case or cases of COVID within 1 mile of each of these premises. And in my respectful submission, that's just not the case. And the Stonegate decision, which I'll come to, was totally different, because the peril in Stonegate was, as one sees...
Sorry, just before you come to Stonegate, if the way I've characterised your argument is right, it involves using a but-for test of causation for savings under this clause in circumstances in which the Supreme Court rejected a but-for test of causation in relation to all the constituent elements of the perils in Arch, because they had to consider this in the context of the trends argument, and they looked at whether it was, you could apply but-for to one of the three or but-for to all three, and in relation to, as I read it, the either analysis, they said none of it works. You can't apply but-for causation. Now, ultimately the question is, why do you then apply but-for causation to the saving when you don't apply it to the operation of the insured
fight my
peril?
battle. I don't stand I'm quite happy to apply effectively a proximate cause based on the basis of a proximate cause rather than a but-for test. But of course, in the context of the FCA test case, the case of COVID in that case was within the vicinity of 1 mile or whatever, was a proximate cause, along with all the other cases of COVID, which were not insured but not excluded.
They weren't excluded.
They weren't excluded. But of course, in this case, what one has got, as we've seen, a number of components. It's not just an insured, a disease, it's not a disease clause, and it's certainly not the type of disease clause that was in Stonegate, which covered the pandemic as a whole in the UK. But in this case, I don't get home on the insured peril merely by proving a case of COVID within 1 mile of the premises. That's just a component of that. And therefore, even if you were to apply the Supreme Court analysis to the danger part of it, that doesn't get me home, because I've got to show before the insured peril involves a prevention of access or hindrance of use as one component, and secondly, I also have to show that it's by reason of effectively a government regulation, the statutory
I
authority.
agree if we're taking them individually, but
If we're taking them
as it seems to
individually,
me that you're on even more difficult ground in saying that there is no proximate cause link between furlough and government lockdown, that's the second element, or interference with the business. You don't get the furlough payments unless there's been an interference with your business. You're only putting your employees on furlough because your business has been interfered with. Interference with the business is a necessary concomitant of an entitlement to furlough payments. Similarly, lockdown was a necessary concomitant of furlough payments because the government made clear that it was doing it as part and parcel of lockdown, and that the furloughing had to be by reason of circumstances arising out of COVID, something like that.
well,
So I understand what you're saying about proximate cause in relation to 1 mile of the premises, although we've got the but-for point on that. So far as the other two are concerned, I'm not sure there's even a but-for argument available to you, is there?
if I can come to the purpose of the scheme, which one sees in the Bath bundle at page C18,
Yeah.
it says the purpose of CJRS is to provide for payments to be made to employers on a claim made in respect of them incurring costs of employment, respect of furloughed employees arising from the health, social and economic emergency in the UK resulting from coronavirus and coronavirus disease. So you've got to, I mean, obviously this isn't part of an insurance policy, but the purpose is to, of a claim is in respect of furloughed employees arising from the health, social and economic emergency in the UK resulting from coronavirus and coronavirus disease. So effectively, it's the pandemic which has influenced the business to furlough its employees. There's no proximate cause test there or anything like that. This is in a government effective handout. And if I can go to 6.1, which is also relevant at page C20, an employee is a furloughed employee if the instruction, which is C, is given by reason of circumstances arising as a result of coronavirus or coronavirus disease. So you may find, and this is the point, a business may have a general downturn in its business because of the pandemic. There's nothing there in the scheme which says you must have been instructed to close by the government. So even though you can say, as indeed it is said against this, that Chancellor Sunak introduced the scheme at around, or didn't effectively referred to the fact that there would be a scheme at the same time as the government closed down the business. There is no requirement that there be a COVID within any distance of any business. There is no requirement that there be any instruction by the government to close the business. All that one needs to show is that the instruction to the to furlough employees is given by reason of circumstances arising as a result of coronavirus or coronavirus disease. And that could just be the general economic downturn caused by the pandemic. Nothing of that. So we say that when they have to show that effectively it was in consequence of the insured peril, they have to show the payment was proximately caused by the insured peril as set out in paragraph in page 140 of the Starboard bundle, which you're well aware, with all the various components elements of that insured peril, not just part of it, not just the disease part of it, for example, which is what the judge did in paragraph 445. He looked very much at the disease part of it and applied the type of reasoning which my Lord Justice Popplewell put towards me, the fact that effectively what's source for the goose is source for the gander. If I succeed in getting a payment for the insurers on the basis of the FCA Supreme Court causation analysis, then that should be applied here. But that's in my respect for submission not good enough, because you've got other components of the peril. So if I can go to Stonegate, which is obviously the earlier case, if we can go to it's the authorities bundle at page 372, bundle 4, tab 4. And what one has here and I'm looking at paragraph 289. And what the judge there says, the other matter which reference should be made is that the decision I've reached in relation to CGIS is different from the conclusion of the full federal court in well, we call it Marrickville, Star Entertainment, in relation to JobKeeper payments, see in particular paragraphs 45163. The relevant clause in that case was a materially different term from the clause in this policy. In this case, the sum save provision required the sum save to be in consequence of the, in that case, interruption interference as a result of the outbreak of disease within 20-kilometre radius of the situation. The full court held the causation requirement was not fulfilled. In the case of the JobKeeper payments as a result, an issue in that case. Here, however, the causation requirements of the CGI should have been received in consequence of covered events, viz. The occurrence of COVID-19 in the vicinity is made out. Indeed, it was conceded by Stonegate. So Stonegate, first of all, conceded that the CGIS was received in consequence of covered events. And the relevant covered event, as I think Mr. Kramer told you, was disease in the vicinity, big V. Big V, vicinity, was a defined term. One sees that at page 314. And the whole of the UK was said to be in the vicinity. So we see, exceptionally, the coronavirus pandemic itself, where in the whole country, was the subject of coverage in the Stonegate case. And in those circumstances, if one, in a sense, goes back to say, well, one goes back to Bath, and one sees that the instruction has to be given by reason of circumstances arising as a result of coronavirus or coronavirus disease, paragraph 61C in the scheme. Coronavirus, wherever it was in the UK, was an insured peril in the Stonegate case. So one can begin to understand, first of all, Stonegate itself arose by reason of a concession. But one can begin to understand perhaps why that concession was made. Because coronavirus generally in the UK was an insured peril. There was no requirement in Stonegate that the COVID be any distance, whether 1 mile or 25 miles or what have you from the premises. And I think it's fair to say that also there was no relevant requirement of an instruction by the government, because in my respectful submission, when one looks at Stonegate, the judge was concentrating very much, as one has seen in the passage I've shown you, on the disease peril. So in those circumstances, if one in Stonegate had cover for coronavirus, wherever it was in the UK, one can begin to understand that a claim for or the furlough was a saving which was in consequence of in a sense, the covered event, which was the pandemic itself, which was not this case. Now, Stonegate, in our respectful submission, could be contrasted with the Australian case, the Marrickville decision, which I should show you, which is at Authorities Bundle 6, page 2316. Is that my break? No, it's 1027, sorry. It's one of the perils of me using the PDFs. And one sees at paragraph 445 in the Marrickville case, the relevant policy terms. The sum saved provision of the Meridian policy appears immediately after the description of the cover for business interruption in section 2. This section of the policy is set out above, but it's convenient to restate it here. Cover, if the business carried on by you is interrupted or interfered with as a result of damage occurring to the period of insurance, we will, after taking into account any sums saved during the indemnity period, in respect of such charges and expenses of the business as may cease or be reduced in consequence of interruption or interference, indemnify you in respect of the loss arising from such interruption or interference in accordance with the settlement of claims clause to the sums insured expressed against the relevant item on the schedule, where the schedule notes that the cover has been selected. And the relevant question in that case was whether receipt of JobKeeper payments by the employer meant that any charges or expenses of the business had been reduced in consequence of the interruption interference resulting in insured peril. You can see the insured peril at page 1029. And what one sees the insured peril at paragraph 450. The occurrence of any of the circumstances set out in the additional benefit shall be deemed to be damage to property used by you at the situation. The outbreak of a human infectious or contagious disease occurring within 20-kilometre radius of the situation. So that's the insured peril. The court decided the receipt of the JobKeeper payments did not lead to the conclusion that the charges and expenses of the business ceased or were reduced in consequence of interruption interference. And the reasoning is set out at pages 1033 to 34, paragraph 461. And we say it is convenient, they say it's convenient to start with the second aspect. The requirement is that the cessation or reduction of charges or expenses to be in consequence of interruption or interference. This takes the reader back to the beginning of the cover section where reference is made to the insured's business being interrupted or interfered as a result of the damage. It is that interruption interference we refer to in the sum saved provision. The word damage is given extended meaning by Clause A. Relevantly for the present purposes, the outbreak of a human infectious or contagious disease occurring within a 20-kilometre radius of the situation is deemed to be damage to property used by the insured of the situation. Thus, the reference at the beginning of the cover section, insured business being interrupted, interfered with as a result of the damage, is to be read as including the insured's business being interrupted and interfered with as a result of insured property described in 8C. Returning then to the sum saved provision, the concern is with the interruption interference earlier identified. This interruption interference resulting from the insured peril in 8C. Question then is as follows: assuming a Meridian is able to establish an evident the insured peril in clause 8C is a proximate cause of its loss, as to which and so on, were the JobKeeper payments made and received in consequence of the interruption interference, that is, interruption interferences resulting in the insured peril in clause 8C. As a matter of the application policy provisions, they were not. The criteria for eligibility for JobKeeper payments were financial ones. They did not depend on whether or not there'd been an outbreak within 20 kilometres of the premises of the business. Meridian was entitled to the JobKeeper payments regardless of whether or not there was an outbreak within 20 kilometres of their premises. Conversely, had Meridian not met the financial test for JobKeeper, would not have been entitled to the JobKeeper payments, even if the insured peril in clause 8C occurred. Accordingly, the second aspect of the sum saved provision, the causal requirement, is not satisfied. It's not therefore necessary to consider the first aspect of the provision. So what the Australian I think Federal Court of Appeal looked at were the requirements of the JobKeeper payments, and the fact that you claimed an indemnity based on a disease within 20 kilometres of the premises, the situation, that entitled you to your indemnity. But it was not a requirement to get the JobKeeper payments. The JobKeeper payments were based upon a totally different criteria. It was a financial criterion, and in my respect submission, it's exactly the same here. If one looks at the requirements for obtaining furlough, they were very, almost say, not stringent in any way whatsoever. You might have to show that it's because of coronavirus. I think that does come out from the Treasury scheme, but nothing more than that. You didn't have to show that coronavirus was any distance from your premises. You didn't have to show that there was any government interference with your business. You didn't have to show that effectively your access to your business were prevented by a statutory authority, or that the statutory authority interfered with your business. Nothing of that kind whatsoever. So in my respectful submission, if the Australian court actually applied the authorities correctly and the test correctly, and that the proximate cause in that case was not the insured peril, because the insured peril or proof of the insured peril or the consequence of the insured peril did not lead inexorably to a claim for furlough. You could effectively obtain JobKeeper by satisfying the financial requirements, and indeed you could obtain furlough in this country merely by complying with the scheme. You did not have to show that access or use of your premises was hindered or prevented by a statutory authority by reason of COVID within one mile of the premises. So if I can, and of course in my respect, which is the reason I've said, Mr. Justice Butcher distinguished Marrickville, as we have seen, in Stonegate. And he effectively said the insured peril in Stonegate was different. But the insured peril in Stonegate was different because the insured peril was the pandemic as a whole in the UK, where, as I've said, you can see why it might have been said that that was a cause of the receipt of furlough, because furlough was introduced because of the in the UK. And that, as I've said, is why it seems to have been accepted by the claimant's counsel in that case, that the causation test was satisfied. So we then come to the judgment of the judge. And what one finds what the judge says in the judgment at Court A94, and he which is page 4, paragraph 443. Well, he starts at 443 actually. I agree with Mr. Scory's submission. There is no reason why the causation inquiry should focus only on the question of whether, in order to receive a CJRS payment, a policy needed to prove those same elements. I consider that this involved taking too narrow an approach to causation. I agree with Mr. Scory's submission. Summary, CJRS or furlough scheme cannot be regarded as a wholly separate and divorced from the restrictions were introduced in consequence of widespread prevalence of COVID. Now, on the contrary, it's clear they were closely connected. Now, if I can pause there, a close connection to, even if the judge is right, a close connection to the restrictions is not, in my respectful submission, the same as proximately caused. And that, in my submission, is the first way the judge went down, I would submit, an erroneous path. It's obviously no coincidence that the first announcement of the furlough scheme on the 20th of March was on the very same day the government announced it would be closing down a variety of businesses. In his statement on that day, the Prime Minister said the government was telling cafes, pubs and so on to close as soon as they reasonably could. When announcing the scheme that day, Mr. Sunak made express reference to the fact the government was now closing restaurants and bars. Those statements were made on Friday the 20th of March. Following days, further restrictions on 23rd of March, further restriction on other business, including retailers such as Liberty Retail, were announced. All of this happened prior to the actual introduction, CJRS of the 15th of April, which Mr. Scory submitted was the appropriate date to consider causation. So he then talks about the furlough, the scheme introduced on the 15th of April. Furlough scheme was thus announced around the same time as restrictions being imposed, was formally introduced alongside the imposition of those who were saying. Ms. Scory submitted the government appreciated the severe economic impact of the disease. Restrictions in the furlough scheme was to mitigate against those. Furlough was therefore part and parcel of a series of measures introduced by the government. And then he goes on, it's of course true, furlough scheme was not simply a consequence of restriction on particular businesses operated by the policyholder in this case. It was a consequence of restriction affecting a very large number of businesses across the economy as a whole. However, the effect of the Supreme Court FCA case that when considering the operation insured peril, a concurrent causation analysis is to be applied. There's sufficient purpose the current policyholder show loss flowing from a combination of insured peril which affected its business, together with similar perils which affected other business. And so the same approach can and should properly be taken when considering causation in the context of the receipt of CJRS payments. Sufficient to show that CJRS and thus payments made pursuant to that scheme is brought into being consequent of a combination of government affecting business of each claimant policyholder in combination with restrictions affecting the business of other policyholders. Well, in my respectful submission, that's really taking that much too far, because what he's doing is effectively saying, well, the government introduced this scheme because the government was closing down businesses generally, and therefore you have a claim on insurance because your business was closed down, and therefore you are claiming furlough, and therefore in some way we have to say that your receipt of furlough is in consequence of the insured peril, even though you are the only one who's claiming on the insurance, who has to prove disease within 1 mile, a government instruction to close down, even though all the other businesses in the country don't have to prove it. They can get furlough purely by showing that in some way their business has been affected by the pandemic. It might be that, of course, if the furlough scheme itself had required you to prove the government had closed you down by reason of a disease within 1 mile, then that type of reasoning might be appropriate, because then you could say, well, the scheme was introduced because the government had closed down businesses because there was COVID within 1 mile of those businesses. And you can look at causation in a sense across the board. But my clients in this case have to go through the hoops of proving disease within 1 mile of the premises, government instruction, and so on. But the other parties who in one sense, the judge looks across to as assisting his case on causation, don't have to prove that at all. All they have to prove is their business was in some way impacted by the pandemic as a whole. So in my respect for submission, that reasoning doesn't work. And then he goes on in 446. In the FCA test case, the Supreme Court said that if possible, trends clauses should be construed consistently with the insuring clauses in the policy. I think a similar approach should be taken in relation to saving clauses. Thus, Mrs. Corrie Smith's case against insurers in relation to peril is a concurrent causation act, relevant action by statutory authority following disease in 1 mile of premises, and that interfered with the policyholder businesses. Equally, the furlough savings were in consequence of what happened, that they were brought in because of damage to businesses caused by restrictions on a large number of businesses, including those claims brought in by the government as a result of the pandemic. I agree with Mr. Scory that what works on one side of the line should also work on the other. But with all due respect, that might have worked if a requirement that the business be closed be a requirement of the scheme, but it wasn't a requirement of the scheme, because historically one of perhaps the furlough scheme was brought in at the same time as the restrictions, and the furlough, the reason for bringing in the furlough scheme was the damage to the economy which restrictions would have caused, does not make effectively one is looking at causation, a chain of causation in that respect, and does not make the restrictions which are specified in this particular insurance provision the proximate cause of the furlough scheme. That effectively has to be the argument of the insurers, that effectively the furlough scheme was brought in consequence of the insured peril, in consequence of government restrictions on premises caused by COVID within 1 mile of the premises. That was not the proximate cause of the furlough scheme. Even if the furlough scheme, even if one were to accept the furlough scheme, was brought in because of restrictions. Those restrictions applied across the board. Those restrictions applied as much to the Isle of Skye, where there was no COVID, I think, until August, as they applied to the centre of London, where there where COVID was rampant. So the furlough scheme and the restrictions were brought in across the board. That there was no requirement. The restrictions were brought in irrespective of whether a particular area was a COVID hotspot or not. The restrictions apply to the whole country. So and the government restrictions of the 21st and 26th of March apply to premises of certain categories, restaurants, cafes, bars, for example, across the board, irrespective of where those restaurants, cafes, or bars were, irrespective of whether there was COVID within 1 mile, 5 miles, 25 miles of them. And we say since COVID within 1 mile of the premises was an essential part of the insured peril, as was a government prevention of access or hindrance but by the government, and since those matters were of no relevance to the receipt of furlough, we say the insured peril was not a proximate cause of the receipt of furlough. And we say that the relevant test is not, was the furlough scheme, or was the furlough received by reason of COVID-19, but by reason of the insured peril. So, my Lord, those are my submissions. I would like to just come back to one point which was been touched upon slightly, which is effectively, are the insureds in this case seeking a windfall? To some extent, it's something which has been touched upon from time to
Well,
time.
the short answer is, if you're right, you're right, and if you're wrong, you're wrong.
Precisely.
If it's a windfall, well, tough. That's just,
exactly.
you know, that's a sort of merits argument. It doesn't really cut much ice.
If
In a
that's
commercial case, Mr. Gruder,
well, if
unless you particularly want to tell us
I
something
don't-
that we haven't already. 'Cause
I don't
I think Mr.
particularly
Kramer
want-
dealt with that to some extent.
I don't particularly. I mean, the parties have agreed a formula,
Yeah.
and the formula must take you where it takes you. So,
Exactly.
unless I can assist you further, those are my submissions.
Thank you. Thank you very much. Yes, Mr. Scott.
Well, those are three issues identified by Mr. Kramer are the cessation reduction issue, causation and collaterality. With respect to that tripartite division, in many respects, there are two main issues. has there been a reduction in causation? Because in my submission, it's rather artificial to dissect collaterality as separate from causation. Another way, in my submission, it's highly implausible the court would conclude that I was right on causation, but then conclude that this was entirely collateral. Because if it is entirely collateral, the court would no doubt conclude causation has not been satisfied.
The other way of looking at it is that if you're right about the policy wording, if you're right about the application of the savings clause, then the raised inter alia acta point is obiter anyway.
Oh, yes, yes. But I will,
I follow your point. But,
yes.
I think it was really the point that both the judges at first instance, both Butcher J and Jacobs J,
Yes,
considered that was the position.
yes. But I'll deal with that briefly. Now, the correct starting point in my submission is, when construing the language, is to bear in mind the indemnity principle. Because a large part of my learned friend submissions have been ignore the indemnity principle. One's not concerned with the actual loss suffered to the bottom line. One is just looking at the agreed mechanism. Now, I fully accept that if the wording adopted meant that the parties were not concerned with actual loss, that might be right. For example, an agreed valuation policy. Then one wouldn't be concerned with the actual value. The parties have agreed the value. That is the measure of the loss. That is not the case here. The policies are concerned with reduction in revenue as the main component to assess the PI losses. But that, as a measure of loss, only makes sense if one takes into account the saved operating expenses. Now, yes, they have then in the saving provision agreed in general terms how that is to be done, but the aim they are seeking to achieve is to identify in general terms what is the economic loss suffered by this policyholder. They are not, in my submission, thereby jettisoning the indemnity principle. Nor, when construing it, should one take an overly technical approach to the construction of that language. Again, one is looking at this from the perspective of a reasonable policyholder. That's particularly important in the context of causation, because one is being asked to look at the phrase in consequence of and give it very different meanings in different parts of the policy. In my submission, consistency is what a reasonable policyholder might expect. And if those words mean one thing in terms of the insured peril, in my submission they should mean the same elsewhere. Now, can I then turn to the gross revenue cessation issue? Now, Mr. Gruder, in his opening submissions, was very frank in embracing formalism, and it's purely a matter of form. In my submission, that is wrong. The policy is looking in terms of what is being indemnified here, the interruption and economic losses to the company, and therefore looks to the economic losses. The form by which that may have transpired is immaterial. And I accept, as I must, that in terms of legal liability, the wage bill remained unaffected. And from a legal perspective, the business retained those employees and retained the legal liability to pay them. That was the very aim of the furlough scheme, to ensure that that situation came about. And the scheme was designed to facilitate the retention of those employees. Yes, true it is that they did so by way of reimbursing the employer. But as Mr. Kramer accepted in response to a question from my Lord Justice Phillips, if there had been a rebate, that would be a saving. Now, the point raised by my Lord is that, well, what about national insurance contributions? Those were rebated in the section 6 of the direction, because the mechanism used to effect these payments was the PAYE scheme. So one has a quasi-automatic system already interface between the employer and the revenue to make these regular payments on a pay-as-you-earn basis. The national insurance.
Isn't the PAYE element also effectively rebate?
Yes. So, but that mechanism means that the government didn't say, stop paying us the money, pro tem, rather than have as it were, a rather bitty, complex machinery. They said, just leave all the obligations as they are. If you, the employer, exercise your public law entitlement to this money, we will refund you the monies via the PAYE scheme. So there was a rebate for the national insurance contributions. The monies for the employee, rather than being paid directly, were paid to the employer. But I do pose a question. Economically, what was the difference? In my submission, formalism doesn't make a blind bit of difference when one is engaged in an inquiry into what is the financial loss suffered by this policyholder, where they have insured financial losses. And in that context, the form cannot matter. Instead, one is concerned with the economic perspective and what is the financial effect to the employer of this scheme. That was the.
That's what my Lord Justice Popplewell called the bottom line.
Oh yes.
The end sort of net result, if you like. The end
Yes.
net result is that they didn't have to pay the wages.
Well, they didn't bear the economic
They
burden.
could bear the economic loss of the wages.
Yes, yes. And they may have been relieved of that economic burden if they put their claim in early, depending on when the payday was.
Yeah.
They may receive the money in advance. They may receive it later. It doesn't matter,
No.
because fiscally, in terms of going to the bank manager and saying, how big do I need my overdraft to be to keep going, they were not paying 80% of the bill for the wages, and therefore pro tanto reduced to that amount. And if one asks a reasonable policyholder buying this, if you are given 80% rebate, grant, whatever the name, by the government, so that you're not bearing that burden, is that a saving? In my submission, the reasonable policyholder would say, yes, of course it is. That's not borne by my business.
Yeah.
That was a view taken by Mr. Justice Butcher in Stonegate. You've been shown those passages. I say that the learned judge was right for the reasons he gave. Mr. Gruders took you to Ms. Cramer did rather, the passages that was adopted by Mr. Justice Jacobs below. And I say that those judges were right for the reasons they gave. They looked to the economic, commercial reality. Now, given that the approach to construction of contracts is to look to the commercial reality, the idea that one should engage in a formalistic approach is, with respect, an antithetical approach to construction, and one which should be deprecated as opposed to adopted in this case. Contrary to what was said in the submissions by Bath, support for a different conclusion cannot be found in Marrickville in Australia. The full federal court did not deal with this issue. It focused exclusively and only on causation and expressly said they were not addressing the reduction point. And if one reads my learned friend Skeleton in the Bath case, paragraph 26, footnote 14 quickly, one might be forgiven for thinking there was a suggestion there that the first instance judge was sceptical about the reduction point. That is wrong. If one looks at Mr. Justice Jago at first instance, I'll just give the court the references. That's in the bundle 5 of the authorities. And if one turns to page 646, at paragraphs 623 and following, there the judge had little hesitation in concluding that the job seeker payments did indeed operate to reduce the costs of the employees and the wage bill from the perspective of the employer. So there the judge takes a very, as it were, economic view, akin to that of Mr. Justice Butcher and Mr. Justice Jacobs. There is a distinction drawn on page 647, paragraph 626, in respect of more general grants which were not hypothecated to a particular purpose. But in respect to the JobKeeper's payments, that was held to reduce the underlying bill. And we say the judge was right to conclude that, as were the first instance judges in this jurisdiction. Can I also deal with the point made at the outset by Mr. Kramer about whether there is any relevance to whether the wage bill was incurred? Now, you'll recall this primarily was focused on the unamended wording of the Starboard and Gatwick policies. That's the standard wording. That is irrelevant in my submission, where we are dealing with, on all the policies before this court, wording which was agreed to be seesaw reduced. It is neither helpful nor appropriate to construe seesaw reduce by reference to incurred, which was not the language of this contract. In any event, I do not accept that if the language were incurred, that would make any difference to the proper interpretation of a savings provision, because one wouldn't need to stretch the interpretation too much, certainly not as far as one would in a synergy type analysis, to say that, well, yes, the cost still may have been legally incurred, but did the business economically incur the burden of that wage bill? And the answer will be no, it was reduced by 80%. So even if formally incurred, it was not economically borne. And one can test it this way. If one has a business which has a claim for business interruption, and it had who had been rewarded for promotion of good industrial relations with the staff by a pay rise. But he was such a good manager, he said, thank you, but no thanks. I don't want to cause any problems with the rest of the staff. So he'd formally been awarded a pay rise, it had been incurred, but he'd not taken it. In my submission, in that situation, the fact that it was formally incurred would not permit a policyholder to say, well, that's the cost I've had to bear, when in fact it was the lowest sum because of the employee foregoing it. Again, one focuses upon the economic reality. There is in writing the issue of the timing point. That's not been dealt with orally. I don't really tend to say anything more, that it makes no difference.
Sorry, the timing point.
Whether these monies are paid before or after the date
Well,
of the...
I don't think there's any evidence any of the monies in these cases were paid before.
No.
But the point that was being made was that the scheme contemplated that they might be.
Yes, my submission...
Just a support. I mean, the judges seem to think that that was a further support for the conclusion they reached.
Yes, if one goes down the economic analysis, then in my submission the timing point is irrelevant.
Yeah.
I'm not sure I need to say anything more on the issue of cessation or reduction. As I can say further, I can move on to the causation point. Now, just briefly, by way of introduction here, the issue is whether the furlough payments were in consequence of the incident or damage. There is common ground, there's no dispute, that that must be read as if that were in consequence of the insured peril, and in consequence of imports a causation analysis. But what I'm going to say tomorrow is going to echo the points that Mr. Gruder very helpfully read out that I made below before to Mr. Justice Jacobs in terms of my submissions on how causation operates in the context of the savings provision and how one takes a consistent approach to the phrase in consequence of. Namely, one has the Supreme Court's view about how that works for the insured peril. One has the Supreme Court's view as to how that works in terms of the trans clause, which again is looking at the other side of the equation to see how one calculates the loss. Savings is again that side of the equation, the same as the trans clause.
Well, the trans clause could be that side of the equation. So potentially it reduces the loss, doesn't it?
It could be, my lord. Yes,
Yeah, it could be.
It could be either. And it just and the thrust of my submissions is that if it means one, it means everywhere. But that may be a convenient moment, my lord.
Yeah. Okay. Well, that's great. 10:30 then.
All rise.